everyone. So I am gonna begin with Unit 6 in this video, that is International Law. The word itself is enough to suggest its meaning. Law, everybody knows by now, I guess. We have did class 11 also, and class 12 is chapters are half over. So law, everybody knows, right? International law means the laws or the rules which are made at the international realm, that is to regulate the relations among countries of the world. And since in today's era we have globalization to a greater extent, everything is available across borders, across nations, trade, commerce, business, import, export, tariffs, etc. And we can access to anything which is not Indian, like not only Indian websites but also some of the journals which are published by maybe USA, a citizen of USA, or an organization, institute of USA. We can easily access this on the net, right, by click of a button. So the world has come into hands, or it is reduced to a computer screen in front of us, right? So because of that globalization and the countries interacting so much in today's world, it is important that some laws should be there to regulate those as well, right? Because if I am regulating, or if there are laws for a particular country to regulate the affairs or the human conduct within that national jurisdiction, and every state of India also, for example, has its own some local laws that would govern the relation of people or the conduct of humans, for that matter, in that particular jurisdiction of a state, right? And we have various laws, like we did contract law, property law, and by now I guess it was the second or third chapter of this book. By now I guess you know what is contract, what is property law, right? So that conducts the that regulates the conduct of its citizens and the transactions that two or more people or organizations may enter into with each other, right? For that we have domestic or municipal or local laws, fine. So domestic, municipal, local, all these are the expressions given to the laws which are made by a particular government to regulate matters happening within its own national jurisdiction, right? And as we know, hardly there is any country in today's time which is not sovereign, right? So every country is sovereign. That determines the fact that every country has its own set of rules and regulations that governs or regulates the conduct of its citizens, right? Because there are so many people, and it is important for the society to be in proper law and order situation, for them to live in harmony, right? Even in a family of many brothers, 2 or 3 brothers, there are fights, there are points of differences, since every person has a different perspective of viewing a particular thing, right? Or of choosing something, of giving an opinion to a certain issue, right? So there may be difference of opinion that may lead to fights or disruptions in the family. A family is the smallest unit of any society. If there are disruptions in the smallest unit of society, then society as a whole, state as a whole, and then country as a whole is a very huge level at which many descriptions can take place, because of which the regulation of conduct of citizens is important, and that regulation is done by the local laws, right? So I hope this thing is clear. Private, social, commercial, other activities of individuals are controlled. But what happens when there is a dispute between 2 or more state parties? State here means nations. Okay, so every country has its own set of rules. Fine. For any matter which is occurring within its jurisdiction, that will be dealt by those set of rules which are prevalent in that area, in that nation. But what about if there is a dispute between 2 nations? Both of those 2 nations have their own set of local laws. The rule of country A will not be applicable on the people of country B. And for that matter also we can say that the rules or laws of country A will not be applicable on country B, and vice versa. And we can also say that we cannot force the country B to be bound by the rules of country A and vice versa, right? We cannot say that क्योंकि उनके rules अलग हैं, वो country sovereign है, हमारी तरह वो भी sovereign है, तो हम उसको force नहीं कर सकते हमारे laws मानने के लिए, ठीक है? सो ऐसे सिचुएशन में कौन से लॉज एप्लीकेबल होने चाहिए? कैन वी डू कि ये कंट्री बड़ी है या ये कंट्री पावरफुल है तो ऐसा करते हैं इसके लॉज को इस पर बाउंड करवा देते हैं. दिस वुड बी इनजस्टिस और अनफेयर टू कंट्री बी, राइट? सो ऐसे कुछ डायमेंशंस या क्राइटेरिया नहीं है टू डिसाइड कि किस कंट्री के लॉज ज़्यादा सूटेबल या एप्लीकेबल होने चाहिए ऑन अ पर्टिकुलर इशू. एंड अमंग नेशंस मेनली जो ट्रांजैक्शंस कैरी आउट किए जाते हैं वो है बिजनेस. ट्रेड ही तो होगा बेसिकली दो कंट्रीज़ के बीच में. मेनली हिस्टोरिकल एवोल्यूशन. द टर्म इंटरनेशनल लॉ वॉज फर्स्ट कॉइन्ड बाय English philosopher Jeremy Bentham in 1780. This is a very important factual information and a question of one-liner, not only in your class 12 examinations but also for competitive ones. So you need to learn this, that who has coined the term. Jeremy Bentham, 1780. Dutch jurist Hugo Grotius is considered to be the founding father of modern international law and greatly influenced the development. So the founding father is Grotius. That also you need to remember. And these are some factual informations which is very important. तो आप इसको neglect नहीं कर सकते. Grotius emphasized freedom of high seas, an idea that rapidly gained acceptance amongst Northern European powers that were on a mission to explore the world and colonize it. Means they were on a mission to explore the world and also to make them their colonies. Colonies का मतलब सबको पता है because we were also the colony of Britishers, right? And this freedom of high seas is basically it is not the territory, it is not under the territorial jurisdiction of any particular country, but इस पे सारी countries जो है free of any jurisdiction है और that's why it is known as freedom of high seas. And it is the vast area of water जो कि country के exclusive economic zone के बाद का होता है and no country can claim jurisdiction over it. तो इसके फ्रीडम को कॉइन किया था या इन्होंने ग्रोशियस ने इसके फ्रीडम के बारे में बोला था that it should be free of jurisdiction, and that was agreed by at that time European powers were the developed and powerful. तभी वो बाकी नेशंस को जाकर कंट्रोल कर पा रही थी, वो पावरफुल थे, डोमिनेटिंग थे, उनके पास रिसोर्सेज थे. दैट्स वाई दे वर एबल टू एक्सरसाइज देयर कंट्रोल एंड सुपीरियॉरिटी ओवर अदर्स, राइट? अगर उनके पास ये चीज़ें ना होती तो वो कैसे मास्टर्स बनते और हम कॉलोनीज. Origin is embedded in history and can be traced to cooperative agreements between people in ancient Middle East, but the essential structure was mapped out during European Renaissance. Cooperative agreements, agreement is also on the basis of cooperation between the people who have entered into that agreement. कुछ टर्म्स एंड कंडीशंस पार्टी ए की मानी जाती हैं, कुछ टर्म्स एंड कंडीशंस पार्टी बी की मानी जाती हैं और दोनों आपस में कंसेंसस या अग्रीमेंट के साथ वो टर्म्स एंड प्रोविजंस को प्रोविजंस ऑफ अग्रीमेंट के तौर पर अग्रीमेंट में लिख देते हैं. एंड दोज टर्म्स एंड कंडीशंस ऑफ ईदर पार्टीज ऑफ बोथ द पार्टीज बिकम द clauses of the agreement entered into between them. International law versus domestic law. International law is an independent system that exists outside the legal orders of particular states. Okay, because it is an independent system of law, it is made by those international organizations like WTO, UN, right? So they are responsible for governing on the basis of international law. Other than that, every state has its own domestic law to govern the citizens, right? So it is an independent system which exists outside the legal orders of states. That means states do not have the states cannot give orders on the basis of international law, क्योंकि वो काम इंटरनेशनल बॉडीज का है. स्टेट अपने जुरिस्डिक्शन के साथ डील करने के लिए ही ऑथराइज्ड हैं. UN General Assembly consists of representatives of around 190 countries. Although it has an outward appearance of a legislature, but it has no power to issue binding laws. As I have told you, international law is said to be a weak law since it has no binding force, and if any law is made by the UNGA, that is United Nations General Assembly, if it is violated or not obeyed or related to that law, implementation is not made by the countries in their own domestic laws, उसके लिए कोई भी पनिशमेंट, फाइन, कुछ भी एनफोर्स नहीं किया जा सकता है. While if you compare such violation of a domestic law, तो I think you know by now कि क्या repercussions follow कर सकते हैं, right? It appears to be a legislature, but it is not, because legislature frame laws that are considered to be binding on the citizens, meaning thereby if they are violated or if they are not obeyed by the citizens, repercussions will follow. Resolutions passed serve merely as recommendations. They are only advice, because every state is sovereign in itself, so you cannot bind those states by external pressures of UNGA, right? So they are only recommendations that ये laws इस issue पर, which is more prevalent, इस issue पर हर एक state को laws बनाने चाहिए, ठीक है, या इस issue को states को consider करना चाहिए. And whatever resolutions are passed कि ऐसा ऐसा है, जैसे women inequality पर है या उनके जो domestic violence है, if I talk about CEDAW that we did in the last class of class 11th, right? तो CEDAW में क्या था, women के against जो भी all kinds of discrimination होता था, violence होता था, उससे related convention है, तो इसमें आपको laws बनाने चाहिए. So whatever provisions are being passed of the UNGA or ICJ rules, उसको पैरेलली एनफोर्स करवाने के लिए या तो रेटिफाई करना पड़ेगा इंडिया को, या अपने स्टेट में मतलब डोमेस्टिक लॉज बनाने होंगे ऑन दैट मैटर. ये हम कर चुके हैं, राइट? इसीलिए पॉश एक्ट और पॉस्को एक्ट आया था. To determine UN budget while admitting new members of UN, electing new judges to ICJ along with Security Council. So these are some of the decisions in which resolutions are binding, जहाँ पे appointments होनी हो, judges हो या फिर UN budget हो या new members हो, so उसमें it is considered to be binding with veto powers to certain states or nations. International court system does not have absolute jurisdiction. In contentious cases, ICJ's jurisdiction requires consent of particular states that are involved. Now see, jurisdiction भी नहीं है. Do Indian courts require the consent of parties to the dispute? कि हम क्या आपका मैटर डील कर सकते हैं, क्या वो कंसेंट लेता है उनसे? नहीं. But here, since every state is sovereign, again and again I am saying the same thing, because वही एक रीज़न ही है. तो अगर आप दो स्टेट्स के रिलेटेड मैटर को उठा रहे हो सुओ मोटो या ऑन एप्लीकेशन ऑफ अ पार्टी, then also you have to take the consent of the other party, that is the other country involved, कि क्या हम ये jurisdiction carry out करें, तभी आपको jurisdiction मिलेगी, and then only you will be able to continue with the case. और उसके बाद भी जो judgment आता है, that is also not legally binding upon those two nations, because again international law is a weak law. No international police force, system of law enforcement, no supreme executive authority. आप इन सब पॉइंट्स को इंडियन लॉ से रिलेट करेंगे तभी दोनों में डिफरेंस समझ में आएगा. वाई इंडियन लॉ? बिकॉज दैट इज ऑल्सो अ डोमेस्टिक लॉ फॉर दैट मैटर, एंड द सेम पॉइंट्स ऑफ डिफरेंस विल बी एप्लीकेबल टू द डोमेस्टिक लॉ ऑफ एनी अदर कंट्री. ठीक है, यहाँ पर पुलिस फोर्स है, लॉ जो भी लेजिस्लेचर ने बनाया उसको एनफोर्स इम्प्लीमेंट करने के लिए एग्जीक्यूटिव है, बट इंटरनेशनल लॉ सिस्टम में ऐसा कुछ नहीं है. UNSC may authorize use of force in specific cases to compel states to comply with its decisions only when there is a prior act or threat of aggression. Any such enforcement action can be vetoed by any of SC's 5 permanent members. The forces involved must be assembled from member states on an ad hoc basis as there is no standing UN military. हर एक कंट्री की अपनी आर्म्ड फोर्सेस होती हैं, मिलिट्री होती है, यूएन के पास नहीं है. सो इफ देयर आर सीरियस थ्रेट और एक्ट्स ऑफ वायलेंस एंड देयर इज अ डेंजर दैट ह्यूमन राइट विल बी वायलेटेड ऑफ अ ह्यूज नंबर ऑफ पीपल और ह्यूज लाइफ ऑफ लॉसेस वुड टेक प्लेस अगर ये एक्ट ऑफ अग्रेशन नहीं रोका गया तो इन दोज केसेस फोर्सेस कैन बी सेंट और वो भी एडहॉक मीन्स उसी वक्त तुरंत बनाई जाती है बाय द मेंबर स्टेट्स, बाय द हेल्प ऑफ मेंबर स्टेट्स टू स्टॉप दैट अग्रेशन. बट if I take the example of present situation, Russia-Ukraine war or Israel-Gaza, do you find any role of UN or do you think UN was yet till today successful in stopping that act of aggression from either of the parties? No, right? So these are basically, that's why we say it is a weak law. क्योंकि आप कुछ भी कर लो that is only and only in advisory nature. आप उसको बाइंडिंग फोर्स के साथ कंपल्सरली एनफोर्स या इम्प्लीमेंट नहीं करवा सकते. ठीक है. इंटरनेशनल लॉ इज़ वीक लॉ. अनलाइक म्यूनिसिपल लॉ, international law functions in a decentralized manner. All states consider themselves independent, sovereign. Rules of conduct that exist between nations are based on customs of hundreds of years, international agreements and treaties. So whatever relationship are between two or more countries, that is governed by the treaty or bilateral, multilateral agreements that those nations have entered into. So that is also on the basis of the consensus which those nations have themselves reached upon. There is no common consent of community of nation for enforcement of rules and principles for international conduct. So अगर सारे countries इस पे consensus बना देंगे तो इसका मतलब हो जाएगा कि वो international law से bound हो जाएंगे. But there is a reason कि यहाँ पे purified system of law हर एक nation के लिए क्यों नहीं ला सकते, right? Before starting off with Unit 6, I have uploaded the videos of Unit 7, whereby I have told you that why there cannot be a uniform system of law for all the nations. So I will not be repeating that here. Oppenheim's view, international law is a true law. Austen's view, international law is not a true law as any rule which is not enacted by a superior or legislative authority cannot be regarded as a law. So true law का मतलब है it is an actual law, you can say. Austen कहते हैं कि it is not a true law because it is not enacted by legislative authority. As we have did that UNGA appears to be a legislative authority but it is not, because जो भी वो laws बना रहा है that has no binding force. International law and international relations. International law is a distinct part of international relations. States normally conform to relevant rules and principles of international laws while responding to any international situation if and when it arises. The states are conscious to not be negatively viewed by the international community because the international community or foreign companies are important for the development of a particular nation or for the boost of economy to that nation, because those can help in the trade activities, they can do investments, right? तो अगर आप एक अच्छी कंट्री या कुछ इंसेंटिव्स देने वाली कंपनी या आपकी बाहर एक बुरी इमेज बन जाएगी तो nobody will come and like to do trade with you, right? So आपके पास इन्वेस्टमेंट्स नहीं होगी, इकोनॉमी बूस्ट नहीं होगी. तो उस तरफ से अगर हम सोचें तो कोई भी अपनी नेगेटिव इमेज पोर्ट्रे नहीं करना चाहता, या कहने का मतलब है कि कोई भी ऐसी इमेज पोर्ट्रे नहीं करना चाहता दैट आई एम वेरी निग्लेक्टफुल ऑफ द इंटरनेशनल लॉज और मुझे कोई फ़र्क नहीं पड़ता इंटरनेशनल लॉ में क्या बन रहा है, क्या रेजोल्यूशन पास हो रहा है. I am very negligent of taking care of it, or I do not want to consider it, ऐसा सब कुछ वो नहीं दिखा सकते. They have to conform to some relevant or some small set of rules and regulations while they are responding to any international situation. कुछ स्टैंडर्ड ऑफ कोड ऑफ कंडक्ट आप कह सकते हो, जैसे लॉयर्स के होते हैं, दैट वी डिड इन यूनिट 7. उसी तरह से जब नेशन, कोई भी गवर्नमेंट, यूनियन गवर्नमेंट ऑफ एनी स्टेट रिस्पॉन्ड्स टू एन इंटरनेशनल क्राइसिस, तो कुछ एक रूल्स एंड रेगुलेशन है जो कि उसको फॉलो करना पड़ता है अगर कुछ इंटरनेशनल क्राइसिस आया, बिकॉज यू कैन नॉट पोर्ट्रे योर नेगेटिव इमेज. फॉर एग्जाम्पल, इंडिया ने जो अभी स्ट्राइक किया था ऑन पाकिस्तान रिसेंटली आफ्टर द पहलगाम अटैक, उसमें भी कितने सारे नेशन के डिप्लोमैट्स को कॉन्फिडेंस में लेने के बाद किया था, राइट? So the rules of international law are based on reciprocity or self-interest. That means self-interest means to think about the rights or interest of the own nation, and reciprocity means reciprocal. In maths you may have done reciprocal fractions, right? So एक दूसरे का उल्टा, right? So reciprocity in international law refers to that if I am providing some facility to a national of country A, then that country will also respond to me in contrast. Okay, it will also provide the same facility to the nations of my country. So that is basically reciprocity. And for various fields in international law, there are some reciprocal agreements that are entered into by the governments of various nations with each other, in which they agree to provide certain facilities to the nationals of each other's country, right? For example, there is a reciprocal enforcement treaty between India and England regarding that, in India and USA also, that if any judgment of Indian parties, there were 2 Indians residing in USA for example, and since they were residing in USA, so if a dispute arose, the US court or the particular state of that USA would have jurisdiction over it, right? Because the matter or the dispute has arisen in its local area, so it has conferred a decision on that matter. Now when the parties or one of the party जिसके अगेंस्ट वो डिसीजन गया है, वो आकर इंडिया में वही केस फाइल करता है, या if after some time both parties return to India, now they want the same judgment to be enforced in India, कि हम उस जजमेंट के साथ ही बाइंडिंग करेंगे अपने आप को in India also. So for that, see, USA judgments or USA laws for that matter are not applicable, are not binding in India, right? Because they are different legislations for a different country, and we are only governed by or binding by the legislations of our own nation, right? So to enforce that into our nation, we have that reciprocal agreement. अभी के लिए सिर्फ इतना ही एग्जाम्पल काफ़ी है. आई एम नॉट delving much deep into this because it may be very tough, or you will it may create confusion, so let's leave it here only. So reciprocity means exchange offer sort of provide karna. Breach in international rules, breach means to violate, to break. International rules by a state may result in loss of its credibility and affect the future relation with other states. So that's why you have to not portray a negative image. So they are image conscious in front of the international community, because the relations with other states in future may get affected, because as we know that no nation is self sufficient, right? Import and export हर nation करता है किसी ना किसी सामान का from other nations. And also in cases of natural disasters, in events of natural disaster, or if some other nation has attacked that nation, so it may seek help or assistance ally from the other neighboring nations of the world. So for that also relations are to be maintained. And if you don't have good relations, then who will come to help you, right? You will be all alone in that crisis. So to avoid that, good relations are important to be maintained. But if a negative image is portrayed, or you have regularly been ignorant and not obeying the international rules, that will also portray a negative image that will result in the loss of credibility. Credibility means the others will not be able to believe in the functioning or in the way the state is carrying itself, because it's like कि आपने बार बार वो चीज़ ब्रीच करी तो लोगों का भरोसा उठ गया आपके ऊपर से. If a particular nation is keeping itself bound by the international rules, it will also expect that the other nations would also follow the same set of rules, right? That's why they are uniformly created for all the nations. तो अगर एक कंट्री उस रूल को फॉलो करते हुए काम कर रही है और किसी दूसरी कंट्री के साथ कोई ट्रेड या कॉमर्स में इंडल्ज हो रही है, वहीं दूसरी कंट्री उस रूल्स को बार बार वायलेट कर रही है, तो लॉस ऑफ क्रेडिबिलिटी तो होगा ना. नाउ मे बी इन फ्यूचर दैट कंट्रीज विल नॉट लाइक टू ट्रेड विद यू, राइट? दे विल नॉट लाइक टू कीप एनी रिलेशंस. तो फिर आप कहाँ से ट्रेड, कॉमर्स या एक्सपोर्ट इम्पोर्ट करोगे? हाउ विल यू arrange the articles which are required by the citizens of your own country? That will be very difficult. If a state violates a treaty to its advantage, it may induce others also to breach the treaties. This may ultimately cause harm to the state that first violated the treaty. Now if your own advantage, अपना खुद का फ़ायदा देखा कि हमें इसको वायलेट करने में फ़ायदा है, तो आप तो वायलेट कर जाओगे. इससे आपके वायलेशन से कोई और कंट्रीज़ एडवर्सली अफेक्ट भी हो सकती हैं, and it can also portray a wrong example to the other nations that they can also violate and they will be set free, because we know international law is a weak law. अगर आपके साथ कुछ नहीं हुआ, उनके साथ भी कुछ नहीं होगा, right? So a wrong example will be set up, and if the other nations start violating the treaty, then the first nation, the state that first violated the treaty, उसको भी कभी ना कभी कुछ adversely affect होगा, right? That is what is said over here, may ultimately cause harm. There is a idiom, no, in English, what you sow, so shall you reap. So अगर आपने violate किया जिससे adversely affect हुई, तो एक टाइम आएगा जब आप भी adversely affect होगे, because the other nations have followed your footsteps, right? When international rules and principles are followed by states, it creates value of certainty. That means it is sure, it is certain that everybody will follow the same set of rules. तो जो चीज़ें या जो events भी होने हैं, जो trade and commerce होना है, वो इसी certain aspects पर होगा. Predictability, that means you can predict, you can foresee कि आगे क्या क्या हो सकता है on the same lines of rules and procedures. And a sense of common purpose in international affairs, right? Globalization in 1980s resulted in increase in international regional organizations, both in number and influence. Globalization resulted in the increase of, since there was globalization, so everything came to a very concise एरिया, राइट? वी से द वर्ल्ड इज़ इन आवर हैंड्स. इतना छोटी हो गई है अब दुनिया कि हाथ में समा जाती है. क्यों? क्योंकि एट द क्लिक ऑफ अ बटन यू कैन एक्सेस एनीथिंग फ्रॉम एनीवेयर, राइट? सो दैट हैज़ रिजल्टेड इन, नाउ सी, द जुरिस्डिक्शन और द एरिया हैज़ एक्सपैंडेड. तो अब उस इतने बड़े एरिया को रेगुलेट करने के लिए जो लॉज होंगे वो भी एक्सपैंड होंगे. तो अगर हमारे हमारा सिर्फ एक ही नेशन है, लेकिन दुनिया में कितने सारे नेशंस हैं, राइट? So in one nation we have different commissions, National Commission for Women, National Commission for SC, ST, etc. So those are the organizations or bodies which are set up for particular purposes that they serve, right? तो उसी तरीके से when globalization happened and the jurisdiction or cross boundary trade and commerce increased to next level, it expanded extravagantly, then it was important to make laws that could cover the whole area. So the international regional organizations also increased in number, means there were more number of जैसे जैसे एरिया एक्सपैंड होता गया, जैसे जैसे नंबर ऑफ़ कंट्रीज़ बढ़े उनके बीच में डिस्प्यूट्स हुए, उन्होंने ऑर्गेनाइजेशंस बनाई. यूरोपियन है, दैट इज़ फॉर ओनली द यूरोप. देन वी हैव UN, दैट इज़ फॉर ऑल ओवर द वर्ल्ड. सो दे इंक्रीज्ड. जहाँ पहले सिर्फ 4 इंटरनेशनल ऑर्गेनाइजेशंस थी 1980 के पहले, आज की डेट में कितनी सारी हैं, राइट, फॉर डिफरेंट पर्पसेस. सो दैट हैज़ इंक्रीज्ड इन नंबर एंड इन्फ्लुएंस. उनकी इन्फ्लुएंस भी धीरे धीरे बढ़ती गई, क्योंकि व्हेन द इन्फ्लुएंस वाज निल और नेग्लिजेंट, द कंट्रीज़ वर वेरी इग्नोरेंट ऑफ इट. तो इसीलिए उनकी इन्फ्लुएंस को सारी कंट्रीज़ के कंसेंसस के बाद ही बढ़ाया गया, ताकि एक एटलीस्ट एक स्ट्रॉन्ग इन्फ्लुएंस बन सके, एक प्रेशर बन सके अमंग ऑल द कंट्रीज़ ऑफ द वर्ल्ड. बट स्टिल इट इज़ अ वीक लॉ. This has resulted in expansion of international law to cover rights and obligations of international organizations. So international law में भी expand हुआ, in the sense that now it would cover the rights and obligations of these organizations. Organizations बड़ी, उनकी क्या पावर्स हैं, फंक्शंस हैं, राइट्स हैं, ड्यूटीज़ हैं, उसको भी तो प्रिस्क्राइब करना पड़ेगा ना. जैसे हमने NCW बनाया, नेशनल कमीशन फॉर वुमेन, तो हमें उसका कॉम्पोजिशन पता होना चाहिए कि कौन कौन इसके मेंबर होंगे, वो कैसे फंक्शन करेंगे, हर एक मेंबर की पावर, ड्यूटी, फंक्शन क्या होगा, उस पूरे कमीशन का काम क्या होगा, हाउ इट विल डील विद द अदर ऑर्गन्स ऑफ द गवर्नमेंट, और व्हाट इज़ इट्स मेन पर्पस, हु इट हैज़ टू गिव इट रिपोर्ट्स, और कितने एनुअल कितने रेगुलर इंटरवल्स में वो अपनी रिपोर्ट सबमिट करेगा. सो ऑल दैट ऑल्सो हैज़ टू बी गिवन, राइट. सिमिलरली इफ़ इंटरनेशनल ऑर्गेनाइजेशंस हैव इंक्रीज्ड इन नंबर एंड इन्फ्लुएंस, तो उनकी इन्फ्लुएंस कितनी बड़ी है उसको भी तो कहीं नोट डाउन करेंगे ना. सो दैट इज़ वाई द इंटरनेशनल लॉ ऑल्सो एक्सपैंडेड. New international law is now frequently created through processes that require near universal consensus. Near universal means approximate पूरे जितनी भी nations हैं in the world, उन सब का agreement होना चाहिए. For instance, in area of environment, bilateral negotiations have been supplemented and at times been replaced by multilateral ones, transforming the process of individual state consent to community acceptance. This consensus building process has resulted in various environmental agreements and law of sea treaty 1982. We have Kyoto Protocol, we have Paris Protocol, right? So these are what? टू दी आफ्टर, जैसे जैसे मतलब प्रॉब्लम्स आती गई उस हिसाब से हमने अग्रीमेंट्स बनाने शुरू किए, दैट नाउ वी हैव टू डील विद दिस प्रॉब्लम. सो नाउ ऑल ऑफ द नेशंस हैव कम टुगेदर टू डील विद इट. सो सबसे छोटा यूनिट क्या हो सकती है, व्हेन 2 parties agree to something, that is bilateral negotiation. Okay, when more than 2 parties are agreeing to something, that is multilateral negotiations. And now if it is multilateral, that means the whole group or community of nations have come together, and the next step of it would be near universal acceptance. That means nearly all the nations of the world have agreed to the protocol or to the treaty, whatever it is. And now regarding environment, if I talk about, then there are various environmental agreements, treaties, protocols, that is a set of rules that are made and entered into by various nations of the world. Okay, Kyoto is one of its kind. International law as a system is complex. It is very complex, very confusing at times. In principle, it is horizontal, being founded upon the concept of equality of states, which is one of the basic principles of international law, but in reality, some states continue to be more important than others in creating and maintaining international law. And what are those some states? Which are obviously more powerful and developed, because they always have had a greater influence than the underdeveloped or developing nations, right? They have veto power, that is one example of it, and they also take undue advantage of them having the upper hand. अगर आप उनको upper hand नहीं भी दोगे तब भी वो अपने आप को समझते हैं वैसा और उसी तरीके से काम करते हैं. And since they have veto, so anybody can't even say against that. Fine, they are also made the permanent members. So although we have on theory the principle of equality of all the nations, but in practice it is difficult. So this is also in line with the principle when we say that on paper and in implementation things are very different. There is a huge gap, right? So next we will be beginning with international law in the next video. Thank you so much.